I think whatever y'all decide, if there's some way to mark respondent there and just take a look at it. I mean, it happened again in these next set of pages. Again, I don't want to keep taking up time on this. I know there's some disagreement, so
Maybe we could just make a notation for universal change.
yes. I'm sorry.
We're going to make a notation.
Great. Thank you.
Can I ask a question, Chairwoman? Can staff review it? Because I feel like the grammar piece is, it's depending on what style you use. I think that if they could look at all of the corrections before your next meeting, I think it would be helpful. Because I think that I trust staff's ability to catch the grammar on that stuff. Because I do think there are certain things how we do want to be gender neutral, and I know people are not using gender at all. I think that we need to make sure that we cover it. But I feel like staff has the capability to do that.
Any other comments?
I have a question.
Yes.
On line 1432, completion of probation. So it says, upon successful completion of probation, respondent's license shall be fully restored. Is that usually on the decision or on a particular letter that says like when that date is? It just like, because on other aspects there's like an exact date, like upon signing something or.
Well, when the decision is mailed to the respondent, there is a decision and order page that tells them when probation begins and when it ends. And then when they complete probation, our probation monitor, Curtis Gardner, sends a letter out to them as well.
So it's on the end date of that.
Correct.
Okay, thank you.
Yes, Mr. Fu.
That being said, we do toll, and so that date may not necessarily be a for sure date. Is that correct?
Correct. On the decision and order, we're assuming that everyone is going to comply with the probation and not be in a tolled status. So they'll have the start date and the end date. But again, with the tolling clause, once they complete, they'll be sent a letter saying they've completed probation.
Has there been any issues regarding confusion regarding completion of probation date, or it's never been an issue?
No.
Okay, thank you.
I do. Yes, please come to the microphone.
Is this on, or do I have to push something?
It's on.
Oh, okay. Melody Schaefer, Division 2 of CPA. Oh, let me move this aside. Thank you. Under the tolling for ceased practice, in reading this first paragraph, 1371 through 1375, I guess I'm a little confused. The term of probation shall be extended by any period of time during which respondent is ordered to cease practice, which I'm reading.
Excuse me.
Pardon?
Would you
Page 30,
repeat? And the,
in line 1371 through 1375, under item 26, tolling for ceased practice. Okay, the term of probation shall be extended by any period of time during which respondent is ordered to cease practice, obviously meaning by the board. Respondent's cumulative total time of ceased practice while on probation shall not exceed 2 years. If the board determines the need to extend probation, then wouldn't the time to cease practice would also be extended? Because the next sentence, a cumulative period of cease practice exceeding 2 years constitutes a violation of probation and subjects a respondent's license to revocation. I may be missing something here, but if probation is extended, then the individual most likely, I'm assuming, would be told to continue to cease practice. Yet if the probation exceeds 2 years and ceasing practice then extends beyond 2 years, then you're saying that the ceasing practice exceeding 2 years would be a violation of probation. There's something there that just doesn't quite make sense to me, but I'm probably missing something. Yeah, that's it. 1371 to 1375.
Would the board like me to speak briefly? Sure. I think what this section is doing, just based on my reading of it, is to say that if a licensee is ordered to cease practice initially, and if that licensee doesn't remedy the conditions that caused the cease practice to take effect within 2 years, that's sort of the last straw. If they haven't fixed the situation within 2 years, it's considered a violation of probation. And I think the reason for that is that the board doesn't want someone who's out of compliance that's warranted a cease practice to continue doing that activity in perpetuity.
Can I give an example?
Then it would, if I could respond to this since it was my question, just for my own clarity, then it would make sense to say that probation cannot extend beyond 2 years, would it not?
No.
No.
So one could be on probation more than 2 years, yet practice?
Well, when you're on probation, you can
You are
practice.
practicing.
Well,
You're
this
practicing
is
under-
about ceasing practice, so you're saying you could be on probation more than 2 years, but you cannot be told to cease practice for more than 2 years.
Within that period of probation.
There's something about that that seems
Can I give you an example of when this might
counterintuitive.
come up?
Yeah, sure.
So we might have a probation condition where we ask somebody within the first 90 days, I'm going to pick it, to fulfill a particular condition. If they don't fulfill that, is this correct? If they don't fulfill that particular condition, like they can't pass the CIPLE, we've asked them to take the law and ethics exam again, they haven't passed it. If they haven't done so within the period of time they've been given to do so, we would then order them to cease practice until such time as they're able to pass the exam.
Correct.
And during that period of time, they would be both ordered to cease practice, and it would toll the length of probation. So it wouldn't count against their probation. They'd still have to fulfill a full 5 years. And if they didn't do that within 2 years, they hadn't met that condition within 2 years, then you have a situation in which that's a violation of probation to have not done it, and it may result in termination of probation or something else.
I think that's a great example. My only suggestion, if it is useful, is to maybe, because this lacks clarity to the point that you made, perhaps the verbiage could be changed to elucidate what's meant by that. But thank you, that example would make sense, and then would somehow need to be perhaps incorporated so that one understood it. Thank you.
Thank you.
Our last section will be 31 through 42.
That was just, we just did.
We did?
Yeah.
I mean, yes.
Okay.
Wonderful. Our excitement is we've been working on these for a very, very, very long time, and to have gotten through this quickly is quite a feat. I just want to, Ms. Jones, you had made a suggestion. I just wanted, could you just repeat that for me, for us, please? You had made a suggestion about having staff to, can you hear me? Oh,
I couldn't remember what I had said, I'm sorry.
Oh, you can't?
No, I can remember, he just reminded me.
Yes.
No, I just wanted to say, I feel like, I just wanted to say, I think that staff is very capable about that. And I just think that, because some of the his and her language is a tough one, but I also know that Noreen and all the other staff know the language, because they do all these regs all the time. So I'm just going to say, rather than us go line by line wordsmithing it, perhaps we could just look at the issue, and that's what I was just suggesting, because I think depending upon what time, currently people do there instead of his or her.
Thank you. Okay, wonderful. All right, now, we're ready for a motion for our disciplinary guidelines. Yes. The motion to approve. Oh, I'm sorry. Who would like to do that?
I believe
You may
we're at
go
the,
right ahead.
although I do want to speak to Dr. Schaefer's question to see if there are comments with respect to that language and any need for clarification. But the motion, I believe at this point, would be to approve the language for noticing and set it for hearing, and then a separate motion to delegate to the executive officer the authority to make any technical non-substantive changes and to initiate the rulemaking process.
No, two.
Well, it's
Let's do
pretty
two
long, so you can break
motions,
it up into two, or you can do it as one, whichever you like.
May we have two motions to be real clear?
I'll make one motion, although it's unusual but I'm a member of the committee, so I feel, I'll make a motion to approve the language and set it for hearing.
Okay. Do
I
have a
second.
It's been moved and seconded that we approve to approve the language for the disciplinary guidelines and set it for motion for hearing.
And I have a comment, I guess, to answer Ms. Mark's question about the public comment that was raised. I think that Dr. Schaefer brought up a good question. However, it was clear to me when I read it, but it just makes me remind us, or it reminds me that whatever we adopt, we probably need to have some examples and share if it gets approved to implement it. But I don't think that the language needs to be changed. I feel like it was clear for me. But I do think it's just a great reminder that we forget that we're doing the inside speak.
Thank you.
And just a quick point of clarification, when staff puts together the initial statement of reasons, for every section that's being changed, we will have to explain the changes. So there may be an opportunity to clarify that part in our rulemaking documents.
Thank you. Any other comments?
I think in addition, any of the changes that might be made to that language would be substantive would be non-substantive and technical, just for clarity, that would be within the executive officer's authority, if the board so delegates.
That's the second motion.
Correct, that would be the second motion.
But we've got to finish this first one, and then we'll do the second. Any other comments on the first motion? Hearing none, call for the vote.
Public comment?
Public comment?
Apparently not.
Motion is on the floor. Public comment, no public comment. Now we'll go to the vote.
Akwebudu,
Yes.
Brunel,
Aye.
Kasuga, aye. Erickson,
Aye.
Fu,
Aye.
Horn,
Aye.
Jones,
Aye.
Phillips.
Aye.
Motion's passed.
Thank you. And the second motion?
Second motion would be to delegate to the executive officer the authority to initiate the rulemaking and to make any non-substantive technical changes that may be necessary to initiate the rulemaking.
And I make that motion, which would include my suggestion earlier. So to begin the rulemaking process and to do any substantive changes, including grammatical changes.
Non-substantive.
Non-substantive, thank you, sorry, non-substantive.
Okay. Second?
Almost slipped through there.
And it's a second?
Second.
It's been moved and seconded that we move the disciplinary guidelines forward for non-substantive changes and for the
Delegation to the executive officer to
officer.
initiate and make any of those
Those
technical, non-substantive changes, including grammatical changes.
Okay. And it has been seconded. Any other comments? Any public comments? Okay. We will call for the vote.
Akwebudu,
Yes.
Bernal,
Aye.
Kasuga,
Aye.
Erickson,
Aye.
Fu,
Aye.
Horn,
Aye.
Jones,
Aye.
Phillips.
Aye.
Motion passes.
Now, we will look at the acknowledgment and closure letters. And, oh, sorry. Okay, now we will move forward to the acknowledgment and closure letters. And the first two letters that you see are. Oh, is the- Okay, thank you for that. Thank you. Thank you. So we will look at the complaint form, consumer complaint form.
Madam Chair, may I make a comment?
Yes.
On page 2 of the complaint, oh, that is page 2? They all say page 2. Hold on.
You mean the first one,
This
consumer
is-
Yeah,
complaint?
the complaint.
Are we going page
first
by
one.
page or section by section on this? I guess is my question. Because under the prioritization that goes with this form, the complaint categories and the priority level, I'm not sure if it's aligning with what we were handed today.
Right, we're going to make changes and incorporate the new prioritization checklist.
I'm all done.
Okay, thank you.
I'm sorry, what were you looking at?
If you're looking at the long form, it's page 117 of 502. And this follows, I believe, with the complaint form, I'm assuming.
Correct.
And I forgot that Ms. Monterrubio had mentioned earlier that that will be consolidated with the updated one, so.
Okay.
Okay. Oh,
Any
I-
other comments?
I have a question.
Yes.
On the consumer complaint form, the first section, I'm sorry, the second section, authorization for release of client patient record information. And this may have been discussed before, but there's two things. So it's the Board of Psychology, we're like the front runner in this, we're listing ourselves, or is it the Board of Psychology Department? Because in here it says the board, if you wish to provide the board with additional information, please use a separate piece of paper. I just see the board in here a lot. No, I understand that, so, okay.
No, but what was it?
I understand it's our complaint form, but I think just the way that it's written and I don't know, somehow the public could just think, oh, well, it's really us that are making these decisions. I know ultimately it gets to us, but the way it's written in here, it's just something that is popping up in my mind as it's written. And then also just really quickly, this form, when it is filled out and signed, allows the Board of Psychology Investigation Unit, see that's more clarity to me, it's the investigation unit, to get the records from the only healthcare, should it be healthcare professionals or providers? What would be the correct? Because professional could be a PA, it could be, primary care physician, be a psychologist. I mean, I'm just asking for clarity.
I'm sorry.
I mean, I think,
I may have I think I'm on the electronic,
Yes,
but I don't know what page you're looking at.
I'm looking.
I didn't go on the PDF.
but just to clarify, you're on page 1 and you're under authorization for release of client-patient information, that
Yes.
first paragraph.
Yes.
Okay.
Thank you.
So that first sentence, going back to the board, it says the authorization for release of client-patient record information is a legal authorization for the Board of Psychology, and then parentheses it says boards. And then we kind of use board in the next sentence. Is that okay to keep?
I'm putting it out there.
Okay.
In terms of something that just stood out to me. That was the first one, and then do we want to list it as healthcare professionals or providers?
Staff talked about this. We felt comfortable using healthcare provider. But if you're thinking that's going to be an issue down the road, it's probably something we need to discuss. Noreen, do you have an opinion as to whether or not it should be professional or provider?
I believe that provider would be more specific to the complaint, because you're talking about someone who you potentially have seen as a provider in context of of whatever the conduct is leading to the complaint.
Can I ask a question just about this? This release of information looks to me limited to mental health providing, not anything else psychologists might do for release of records.
What were the last few words you said?
I said, this looks to me to be release of records for
Treatment.
any health service that psychologists might have engaged in. And psychologists do more than provide health services or mental health services. And, I mean, folks may not pay attention to that, it's just for a release of records, but I think we need to be more broad since our license is a general license, the license of psychologists. And it should be anything that a psychologist does that there are records for.
We could say name of provider, or we could say name of provider of psychological services.
That would it'd be totally,
Name of
it'd be
Except
fine.
it wouldn't be just psychological services, because they may have seen other, an MD in connection with the
Right,
complaint.
and that's fine too. I'm just saying for the psychology piece, we really haven't included anything but health service.
Are those records protected to the same extent as mental health records? I don't know the answer to that.
Well, I know, for example, like testing information is, and it doesn't necessarily have to be mental health testing. So I think if we're going to want the work product, then I think we need to evaluations that a psychologist might do for organizations,
So
for
you're saying,
retention of employees, or, those probably aren't protected records. I don't know.
I mean, I was also thinking, though, in terms of whether it be, like, if I'm filing a complaint, right, I could have seen an MFT, I could have seen a physician assistant, I
Right.
could have seen a primary care physician
Right.
for issues that started from, maybe what I felt was an inappropriate comment that my psychologist made or something, and then I
Right.
went on and did further
Right.
medical reviews.
But that's fine but I'm saying there are other things that psychologists do, and that if we want the release of records, then we should include the other
So-
kinds of things.
Would it work to say healthcare providers or provider psychological services?
Absolutely.
To include,
Absolutely. Yeah.
Did we resolve the question of providers versus professionals?
I think we did.
Okay, cool.
So I think it could be name of healthcare or psychological service provider. As opposed to saying provider twice, I think we could make it shorter, because that's going to be a real name of professional, or no, excuse me,
Healthcare.
name of healthcare or professional,
Or
or psychological
service
services provider.
I have a question, though. Below
There.
the numbers, I think I'm on the right page. When it lists all,
Hold on, can we just,
This is signature, this is fill in the blank up on the consent to. Oh, I thought we were up here, are we not? I think we're further up. Aren't we?
no, we're there.
I think that's
Are we
We're there,
further
we're
down?
there, Sharice. Mm-hmm.
I thought it was after provider, adding in or provider of psychological services. Is that what?
Well, I'm looking here, right under the name, address, 1, 2, blah, blah, blah. Release information and records made in the course of my evaluation, diagnosis, or treatment, and including any and all information related to drug and alcohol treatment, medical treatment, psychiatric treatment, psychotherapy, billing records, and all other healthcare-related documents.
She's on page 116
Okay, you're on the actual
of 502
authorization.
in the long form, which is page 3 of that. So
I was looking higher on the form because,
Yeah.
because under
Right.
fill in the blank on number 1 is name of healthcare provider.
Yeah,
I
so
thought
that would
that's where we-
also, that also is fine, but, I mean, I think
Okay,
we
'cause
should change
I
that.
thought that's where you were referring
Okay,
to, so.
yeah. So I think we should change that, but now I'm talking about what we're actually getting a release of documents for, and what we're asking for, the records we're asking for, and some of the things that psychologists do are not going to be health care.
Okay.
And we want to make sure that people have the ability to get those records as well.
Right, I understand that, but I think in order for us to capture the changes, we were talking about the first paragraph.
Right.
Under authorization for release, where Sharice was at, and we were, yes. We were addressing Alita's first comment. Up a little bit. Keep going. Oh, there we go. Okay, so that last sentence where you were at, Carice, where it said healthcare provider or provider of psychological services. We're fine with that? Okay.
Right.
So, but I think, Dr. Phillips, you made a comment about provider twice. So we're saying healthcare providers or provider.
Healthcare or psychological service provider.
Okay. There we go, so we'll take that second.
I'm going to
Perfect.
make a suggestion, actually. I would like to get all the comments in the complaint form, but maybe we could send it back to committee rather than trying to
Yeah,
wordsmith it right now.
just
Otherwise,
kinda say, yeah.
we could be here
That's a
on
good
the
idea.
complaint form for quite a long while. So maybe we can get all the comments, and then we'll go back and look at that issue.
That's good, yeah.
So are we, Dr. Phillips, we continuing to discuss the complaint form, or you just want to send it back to committee?
Oh, I was just, my suggestion was, and it's up to our chairwoman, my suggestion was that we get all the general comments on the complaint form, and then the committee go back and look at the complaint form again and do the final wordsmithing rather than,
That makes good sense. Yeah.
Then, on that first page before we go, under possible disclosure of personal information, yep, huh, what's up there is not what I have in my book.
Is there also some that it went over the next page?
No, go back up. Can you go back up just a second?
Yeah, it's different than what's on the computer.
Yeah, we don't have the
we
same
don't have
one
the same
here.
issue because you're a paper copy person.
I'm on page 116 of 502.
Oh, I see what you're saying.
That's where I made mine.
I have the board makes every effort or something.
yeah.
Yeah, actually, I thought we had,
Yeah.
Yes, what I have starts with the board makes every effort. But it has a reference to licensee, and since the complaint might be about unlicensed practice, I was just going to point that out. But what I have is in my old-fashioned paper copy. Isn't the same as what's on there?
I think that's actually true of the non-paper copies as well, as Ms.
I don't have that.
Ms. Jones pointed out.
What page are we on?
I'm confused.
Out of 502, what page are we on? Are you looking at?
Yeah, she has multiple board members, and so she wants,
It's the
she needs,
first top of the page of the complaint.
and she was doing it wrong. So she's doing it
Oh, the complaint form.
Oh, This is the right,
I'm on the authorization of release of
We
information.
don't have that on there.
The instructions for filing your complaint, that's a page before that, right?
Yeah, sure.
Complaint form, okay.
Oh, here we go. Actually, I found it. Uh-huh. It's on page 113.
That's what I thought, this is not the same as what was up there initially. It was none of this was scratched there.
Oh, it wasn't scratched there, so that was we're looking at the wrong overhead.
Yes. That was like
There we go.
So,
This is
that
what I was.
last line of possible disclosure of personal information says, however, the board may need to share this information with the licensee or other government agency. It just could be, maybe person, because you could be dealing with an unlicensed practice complaint, so it wouldn't be a licensee.
Okay.
So what do you want to change? When you say licensing, you want to put,
Do you want to
you
say
know,
subject,
the
subject of the complaint?
Subject of the complaint?
Subject to the
Okay.
complaint.
comments on the consumer complaint form?
Understand the scope that we are working within.
So hyperlink.
Yeah. I mean, and with the paper copy, obviously, we wouldn't want to send a copy with them, that would be too much, but I think maybe a website where they can locate it for the paper copy, that might help inform where our jurisdiction is and how we approach doing this work and where we are going.
Okay. Any public comments, concern? Oh, yes. Come forward, please. Yes.
Is it on? Okay, sorry. Kathleen Russell, Center for Judicial Excellence. I think this work is fabulous, that you've put so much more thought into these letters. And I guess I would just ask, since there was just a meeting and a directive from the DCA about the prioritization guidelines, that might be included so that the public is aware that certain complaints involving, serious harm to a patient would be expedited. I think that would make the public who are complaining about severe behavior feel like they're being heard and that there's some way that they don't have to wait 36 months for a resolution. Just a suggestion, thanks.
And the suggestion was to expedite the matter?
To include reference to the complaint prioritization guidelines so that they understand that not all complaints are treated equally. And so if there is that there's urgent complaints that take priority, or somehow reference that there are complaint prioritization guidelines that direct the board's work.
Madam Chairwoman, I have a question, a question to that one. I think it's a great idea. Did I read this correctly? Because I know I'm looking at the online version. Ms. Monterrubio, that prioritization is on the back of the complaint form?
It's included in the complaint form.
Oh, okay, all right. Just wanted to make sure, because I couldn't tell if I had went to the wrong section.
Thank you. Yes.
Hi, Jo Linder Crow with CPA. This is just because I don't know the distinction. The first two letters, can you explain? Because the first two paragraphs of both those letters seem the same. So how are those used?
Sure. The letters are pretty much the exact same letter, except for one of them refers to dual licensees. So that last paragraph on page 1 talks about that the individual who the complaint is filed against is also licensed with BBS, and we're referring the case over. That really is the only difference.
Oh, so in the first letter, you're actually referring the case to BBS instead of handling? How does that decision?
What that last paragraph states is, after an initial review of the information submitted, it appears that the person is also licensed by the Board of Behavioral Sciences, in addition to the Board of Psychology. A copy of the information you submitted will be forwarded to BBS for further review. So both boards can work the complaint at the same time. It does not mean that the Board of Psychology will not be working the complaint.
Okay. And does BBS do the same?
Yes.
Okay.
Thank you. Yes.
Hi, I will stay on the topic this time. Do every single one of the complaint gets a letter like that? And what is the time frame in which they receive a letter acknowledging the receipt of the complaint? And is that a specific person, or is it a system where they receive those complaints?
Where they
Where they receive at the Board of Psychology, yes.
So every complaint is opened. Everybody does receive an acknowledgement letter within 9 days. Performance measures, our target date is 10 days. Board of Psychology staff gets those open and sent out within 9.
Unfortunately, it's not real word. I have, in my investigative reporting, I have spoken with at least 20 parents. They do not receive this letter. There's no acknowledgement of their complaints being filed. It's unfortunately what they relate back. I have looked into their emails and notices, so I would like to get more knowledge of how and who received the complaint. Do they have all of them numbers? Are they all comprised in some sort of a system? It's an electronic system. How do we know that they are being looked at?
I have a question for you.
Sure.
Can I- When you said you've talked to these parents, and are they filing with the Board of Psychology?
They have for 2 years submitted complaints over complaints, and they have not received a receipt of their complaints.
But do you know, did they go through this whole process?
They do. I have helped 3 of them to do that, and none of them have received a reply, not in 90 days, not in 2 years. Yeah, and I checked the system myself, and I did not receive a reply. I have gone to the Department of Consumer Affairs, and I insisted 4 or 5 times. I've CC'd presidents, directors, you name it, and eventually I've got an email from the Board of Psychology in a very informal manner asking me what was the complaint number. I said I didn't never receive a complaint number, and so that's an actual fact. It's true. It's happening out there. So I don't know why. I don't know where it goes. I don't know if there's an enforcement or an oversight of where those complaints are going. So we would like to know that, because we know specific people that they have organized their complaints. They wanted to know if it was by the same person and it was a reason why that person was not getting through, or it was a reason technologically that those complaints were not received. So we had a group of parents that they submit complaints at the same exact time. And unfortunately, neither one of them had received this letter. None in 9 days, none, in months following. So I just wanted to bring that up. So I believe the matter of enforcement of the rules that you are so generously developing here, it is more critical, because real world and what happens in those courts, gender bias, the ability that the evaluators being certified by this board, the ability that they have to ruin people's life, it is very real. It is unfortunate, and it is extremely damaging to people's life, and there is no recourse. There is no recourse. Their children are being taken away. Children are committing suicide or attempting to commit suicide. They're being removed from their safe homes, and they're being sent to reunification camps. Evidence-based is not a matter. It's all a matter of psychologists vetting on that.
Thank you
very much. I
Thank you
apologize.
very much.
I just wanted to bring that up. Thank you.
Perhaps Ms. Monterrubio can get the names
Yes,
of those people who have not, and make sure that the complaint is on file.
Sure, I will absolutely provide that.
That would be
Who do I
great.
provide it to?
You can provide it to me.
Okay, do I have your card?
I do it when I
Okay.
get back to my seat.
Thank you very much. Any other questions, comments? Okay. We will move on to our next letter. There were 2 the 2 acknowledgement letters. Now we will move on to our next letter.
Madam Chairwoman, this is the question I had. On this letter and the next letter, I was just curious about the committee's conversation about striking the language related to the consumer satisfaction survey.
Sorry. Every complaint that is fully investigated, we do send out the surveys for people to respond to a couple of weeks after we close the letters. So or close the case. So we did strike out the information from these letters. Some of these letters, though, we're closing because we're not getting all of the information. So we're not going to send surveys to those people because they didn't respond and give us all the information that we initially needed to investigate their complaint. Or we're most likely not going to send surveys out to people also when we're closing no jurisdiction. So if they're complaining about somebody who's not licensed with our board, we're not going to send them a survey. So it's those cases that are fully investigated, we do send out a survey once a case is closed. It's probably about 1 to 2 weeks after.
Thank you. I just remember my work on the licensing committee when we were talking about doing it, so I just wanted to make sure we were still doing it. Great, thank you.
And this was the letter for insufficient evidence, and now the next, are there any?
Yeah, I just have one comment. I think it's on in the second paragraph, the fourth line down, therefore the board has closed its file. I might suggest close its investigation would be maybe better word usage.
Okay, any other comments?
Quick comment in the second paragraph, line 2, insufficient evidence to establish. Would we want to say at the level of clear and convincing evidence? Does that make it too complicated? I'm wondering if a complainee wonders, well, what was the level of evidence that was looked at to establish or not establish that the complaint can go forward? Maybe it's fine the way it is, I'm just wondering.
Okay, do we have any comments on that, or we'll take that up when
In committee.
in committee?
Sure, fine, I'm fine with that.
But let me make sure that we got what you had said. Could you just say it again?
Well, Mr. Tomplay earlier was pointing out the 3 levels of
Yes.
evidence needed, the 51, the 75, and the 95%. I've forgotten the exact language for each, but I think it's clear and convincing for us. Is that correct?
Okay.
Whether we want to mention that or not, I'm not sure, but maybe the committee could look at it.
We will, thank you so much. Thank you. Any public comment on the letter? Hearing none, seeing none, we will move on to the next letter, which is the.
Sorry, just real quickly, instead of, are we on this one, this is the one that's reviewed your complaint and we needed further information?
The
This is-
insufficient, now,
Oh, sorry.
no, but I was just scrolling down from the insufficient evidence, failure to provide additional information. Is that the one you're?
Oh, yes. I just, if maybe the last paragraph or the last sentence in reference, the above noted case, we're just saying submit it to the board. Do we have like a info@BOP or something that is an email address instead of them just mailing it and it could get lost in the mail? Is there like a specific email that maybe we could use?
Enforcement has their own email, so.
Okay, so
we
you
could-
would include that
we could
in this
include
one?
it, absolutely.
Yeah.
Okay. Any other comments from the public? Okay, hearing none. The next letter, no violation and arrest notification.
Madam Chair,
Yes.
I noticed in the previous documents, we struck out control in favor of case number, and the rest notification doesn't do the same thing, and I wonder if there's a distinction between a control number and a case number.
There's not. It should be case number on all of the letters, and we'll make that change.
Thank you.
Thank you, Ms.
It's hard to keep track of these letters. Ooh, there's a lot.
And
then I have a question about that.
Yes.
So I have a question about that one. This says, since the event described in your complaint occurred almost 9 years ago, the deadline established by, so is that our deadline?
The deadline is 7.
I'm sorry?
The deadline is 7.
Took place more than 7 years ago.
Right.
And then, since the event described in your complaint occurred almost 9 years ago.
Right.
So,
Specific information
About it being 7.
about.
Right.
okay, so this isn't actually the language here. This is,
That's not
Right, that can change. The 9 years can
yeah.
change.
Right.
Highlighted areas change depending on the person, case.
Oh, was that your highlight, not my highlight? Oh, okay.
Okay. Any other board comment?
I think the only comment I would have on there says the deadline established by the statute of limitations has passed. The deadline for what? Deadline for file, you might be more specific, the deadline for filing any action against the licensee.
Okay. We can take we'll take the language from 2960.5
deadline
and we'll
more
add that
specific.
to be more clear.
Any other comments, questions, concerns from the board members? From the public? Okay, in our next letter? Yes. You need something, Mrs. Jones?
Was I changing case to control the case?
Yes.
Yes. And the next letter, the notification letter?
Again, that's going to be case number, we're going to do that universally.
Yeah. Okay. Any comments from the public? No public comment? Oh, we're going back to?
Oh, just a quick general question about the email that was listed.
Okay, yes.
Just out of curiosity, Ms. Monterribio, what is the average response time if someone was to email the BOP enforcement at dca.ca.gov?
I would say probably within 2 days.
2 days?
Would be the average response.
So if I had a question about the process of filing a complaint, or if I haven't heard back, I can email that address and I may get a response typically on average in 48 hours or so?
Absolutely. Right now, it might be just a little bit longer because, as I mentioned earlier, we don't have an intake person for enforcement. So we might be looking about 3 days instead of the average 2.
Now, if I, for some reason, the 48 hours is too long for me, am I able to call someone to get clarification?
Yes.
Okay, thank you.
You're welcome.
Ms. Monterrubio, just to be clear, when you say 2 days or 3 days, you're talking about 2 days, 2 working days or 3 working days?
Correct.
So if somebody sent an email on Saturday, it would be 2 days from the beginning of business on Monday?
Correct.
Our next letter. Any board comments? Any comments from the public? The ne-
It says, the information will remain on file in the event of further arrest. What if there's a conviction?
You're on arrest notification.
Yeah, arrest notification. Arrest
Does that change,
notification.
does that change the issue?
I don't think so.
Okay. After arrest notification, the next letter. Okay. Any comments from the board? From the public? None? Our next letter, that starts with, the Board of Psychology has completed the review of the complaint file against it. Any comments from the board, any questions? Yes.
I'm sorry, it remains on file with the board For how long?
Yeah, this,
Yes.
the one on the board that says the Board of Psychology.
Oh, wait, not this one. No, I think it's the next
The
one.
next one might be the next one. You have that one?
No, I think I went. That one.
That one?
The information will remain on file with the board.
We haven't gotten to that one yet, no?
Oh, sorry.
I was the one, no, the one after the arrest one, the one that starts with the Board of Psychology Board has completed, yeah. Yeah. Okay, but it starts with, this is what we're looking at that's on the screen now? Are there any? Yeah, the one that we're looking at right now, this is what we're looking at, that's on the board. It starts with the Board of Psychology. Are we?
Would you like to answer Mrs.?
Yes.
Question?
Yes.
Oh, and so I'm looking at the arrest notification letter?
No, I was for.
Oh, okay.
Okay, any comments, questions on that? From the public? Any comments or questions? Now, the next letter is, we looked at the notification and arrest. Was that the one you were looking at, Ms. Bruno? Okay. Should that be?
Each analyst is given a letter.
Right.
Out of concern for the security and personal staff.
I understand that, but what I'm saying is shouldn't, because it's not always A, it's not always analyst A, so that would change with your microphones are on, right?
Oh,
Yes, it does change. Each analyst will change the letter.
Right.
So,
So I was just saying that should maybe be highlighted
Highlighted.
in yellow, just to, so we know that changes. Yeah.
okay.
Analyst A makes sure that it's changed, I bet.
Any other comments from the board? Public members? Yes, sir.
Dr. Schaefer, Division II Board. I heard someone else speak about the concern of allegedly not receiving the letters sent by the board, and I noticed on the Form 4 complaint, there's a spot for the email address, and I'm wondering if it would make sense to send the letters via email so that the board has some concrete source of stating that the letter was in fact sent, because you can send it with a verification that has been read by its recipient. It doesn't mean it can't still be sent ground mail, snail mail, but you have the email, so that might be a way around that. Thank you.
a copy of all of the acknowledgement letters are submitted to the case file. So we do have a record of each letter.
Do we need to move to adopt this or no?
Thank you. Are there any other comments? Are there any other comments from the public regarding this? And our next letter is the last one. Last one. No, that is the last one. Oh, yes. I mean, oh, yes. Okay, so now I need a motion. Are there any, Ms. Monterrubio, would you like to say something?
No?
Dr. Phillips?
No, thank you.
Okay. Now, we need a motion for the board to adopt the changes to our letters.
I move that we adopt the acknowledgement and closure letters as they were presented with the corrections discussed.
Thank you. Before a second goes, we got a second. Did you
Second.
want to say?
Wait, this is the letter that I was talking about? I'm sorry, before, just this last letter. It just says here in the second paragraph, at this time, the complaint file has been closed, however, the information will remain on file with the board. That's when I was asking for how long.
Just because it's not up on the screen, does it say the information will remain on the file in the event of further arrest? Is that the letter that you're?
No, this is 132. It's the PDF. It's the last letter right before we get to the agenda item 16.
There's two arrest notifications.
So read it again, Ms. Bernal.
It says, at this time, the complaint file has been closed. However, the information will remain on file with the board. And we request that you forward certified copies of the court documents, including any court orders and evidence of completion.
So what that letter is basically saying, because it's an arrest notification and we don't take action until we get a conviction. So we're closing the case on file and it's going to remain closed on file until we get the conviction with the court documents. And then we'll proceed if we need to with the AG's office. And so it's basically just stating it's going to be closed while it's just an arrest and not a conviction.
Okay,
So that can take however long, depending
see.
on the court.
thank you.
Thank you, Ms. Maureen, did you want to say something?
I was just going to suggest that you could have a motion to adopt the committee's report, but you can do it the way in which Ms. Jones suggested as well.
Thank you. We have a second on the motion from Ms. Jones.
Second.
You seconded, okay. So it has been moved and seconded that the board adopts the letters with changes as needed, substantive changes by our executive director, can you say that, of the committee?
Just that, to accept the letters as amended by the board.
Yes, okay.
But a question, Ms. Marks, because we didn't do a motion for B, do you want me to withdraw it and say to do the whole report of the enforcement committee?
She said you could do it.
Oh, okay.
Yeah, that,
Okay.
although the board also did suggest the complaint forms as well, which was a separate item.
Yes.
So if you wanted to do just accepting the committee's report,
Then I'll have to make it.
then it encompasses all of it.
So I'd like to amend my motion to accept the full enforcement committee report.
Okay, so the motion has been amended to include the letters, well, the enforcement committee's report. Okay, all in favor? Oh, I'm sorry, I have a second, and I'm calling.
Some discussion
Oh.
or public comment or anything?
Please forgive me. Public members, I'm not looking over.
Microphone.
Comments from the public? Comments, questions? Please, thank you. It's just that we've been so long with these items.
I'll just keep it short. I noticed that there were, I believe, 9 different letters about closing complaints and denying complaints, and I'm just curious, did the board look at its letters dealing with the fact that you would be moving forward with an investigation? Are those completely okay, or are those going to be dealt with at another time? Just curious why there's only, I think you call them acknowledgement and closure letters, so what about the other letters that would say, yes, we're actually going to open an investigation? I'm just curious if those are adequate and that's why they're not being redone as well. Thanks.
So we do issue the acknowledgement letters and closure letters. We no longer send out status update letters. With close to 1,000 complaints a year, it's difficult for us to send status update letters at every point in an investigation, whether it's going to be referred to the AG's office. If the case is referred to the Office of the Attorney General, we do notify the complainant. So in case he or she has any questions, they can direct those questions directly to the AG's office.
Thank you.
But you have also said that anytime anybody can call and find out a status update, right?
Absolutely.
Yes.
So just quickly, does that mean that any psychologist can call and get an update?
Absolutely, the licensee or the complainant.
Okay, thank you.
Did everyone hear Ms. Monterrubio's answer? You heard? Okay, yes. Okay. Before, any other questions, comments, concerns?
Hi, Elizabeth Winkleman with the California Psychological Association. I just had a question. I know that the licensee is informed when a case is referred to the Attorney General's office, correct?
Yes.
And what about prior to that, when the initial complaint is filed? Isn't there normally a letter sent to when an investigation is open or when a complaint is received? At what point in time would the licensee be informed of that prior to the accusation?
Sure. After we receive the complaint and we start to do the desk investigation, we then notify the licensee in most cases, not all cases, but in most cases, so that he or she can provide us the medical records and a written response. So that is well before the Attorney General office stage. And then for investigations, if it's a formal investigation, they're contacted by the Division of Investigation to set up an interview.
And you said that sometimes they're not in all cases. So in what cases would the licensee not be informed that a complaint has been received?
Well, if we didn't have jurisdiction, so if somebody was, for an example, somebody was complaining about the cost of a therapy session, that's not within our jurisdiction. We wouldn't contact the licensee for that. So it really would just depend. But in most cases, we do ask the licensee to respond and provide us a response to the allegations as well as the records.
So in all cases, sorry, just to clarify, in all cases where there's going to be an investigation, in other words, where there is jurisdiction and something is going to go forward, then in those cases, the licensee would always be informed when an investigation is being opened or conducted?
If it was determined that we might be looking at an undercover, the licensee would not be contacted. So our Division of Investigation does undercover sting operations, so we would not be contacting the licensee to let them know.
Does that ever happen?
It does happen.
Okay, thank you.
Thank you. Any other comments, questions? Hearing none, we'll move forward with the vote. All in favor? Oh, excuse me.
Akwebedu?
Yeah, present. I mean, yes.
Bernal?
Aye.
Kasuga? Aye. Erickson?
Aye.
Fu?
Aye.
Horn?
Aye.
Jones?
Aye.
Phillips?
Aye.
Motion passes.
Thank you. May I just say, I just want to compliment everyone, the entire committee, enforcement committee, that moved forward this piece of work. Well done. Truly, we are a team, and I think that was evidenced here today. And I cannot thank them enough. Absolutely wonderful job, as they always do and have done. And we're so looking forward to the meeting on June the 22nd, where we can really do what we need to do from you all's comment. We thank you, all of you, for your comments. We especially thank the public for your interest and for your comments and just speaking right up. So I just wanted to say thank you. I'm so pleased that I'm a part of this board and a part of the staff is just absolutely wonderful. Thank you.
Thank you.
Okay, well, we're now running relatively tight on time, so we're going to do some, I'm going to do some X-Acto knife editing with what we're up to, and we will be getting to legislative in a second. For the licensing committee, we'd like to restrict to item C. We'd only like to address item C and carry the rest of the agenda over. As I understand, some of those are, there's no particular developments that need to be brought to the board's attention in any event. Sorry, I threw you a curveball, Dr. Horn.
That's okay. Okay, thanks.
19C, or 18C, excuse me.
Thank you. Okay, basically, most everything in the licensing report and the committee report are just informational only. We're still working on things, but we have a couple things that we need the board to weigh in on. So the first is a request for, this is agenda item 18C, psych assistant number 1. This person wants an extension of the 72-month registration period for psych assistants. And the request from this person was for a 10 to 15, as you can see there, a 10 to 15-year extension of the 72-month period. The psych assistant has completed all of the supervised hours required for licensure and has not passed the licensing exam, national licensing exam. So in this period of, this person also has, was requesting this for a couple of reasons. One, in 10 to 15 years, this person plans to retire. But also, this person has had a number of ongoing medical issues that have needed this person's attention. And so what the licensing committee would like to recommend to the board is that to deny the 10 to 15-year extension of the psych assistant license, but to grant a 1-year extension from the current expiration date, which I believe will be this fall. Is that correct, Ms. Chung?
Yes.
Okay. So a year beyond when the 72-month limitation happens, to do whatever else needs to happen in order for the person to get licensed, if that's what the person decides to do, or to make other kinds of arrangements, just to make whatever necessary arrangements the person decides to do. So that's our recommendation to the board. I'd like to move that y'all accept our recommendation. Is there a second?
Second.
Okay, thank you. And is there any discussion that the board has?
I did want to mention one thing that
Yeah.
came up in the course of this. They had their hours for licensing as of 2002.
Right.
So it's already been 16 years since they were eligible to take the licensing exam.
And they did, that person did take the licensing exam a couple of times, 2003, 2004, something like that, so. So are there any questions from, or comments from the board about this recommendation? Do we have public comment on this? Ms. Marks, do we have public comment on this? Is there any public comment on this recommendation? Okay, seeing none, I'd like to, if you make the roll call for the vote, thanks.
Absolutely.
Akwebudu,
Yes.
Bernal,
Aye.
Kazuga,
Aye.
Erickson,
Aye.
Fu,
Aye.
Horn,
Aye.
Jones,
Aye.
Phillips.
Aye.
Motion passes.
Okay, so that's the licensing report. I don't have to move that to be accepted, or,
No.
the only action.
Right, right. The other items we're not discussing.
Okay, so we're going to fast forward to the legislative update.
Can I just say one thing? Just since we aren't reporting on it, I just want to say a lot more people are now sending in renewals online, and that is just great. It saves them a lot of time, it saves us a lot of time, and thank you, thank you.
Ms. Jones?
All right, good afternoon. Item number 21 on the agenda, the legislative update. So the way we're going to go through this, because I can already feel, I know I got to do it quick, President Phillips, we're going to focus on 21A and B, and then jump down to a few of the watch bills, but we're not going to read through each of the watch bills. But if you had any comments, I want you to get prepared when we get to that section to bring up these items. Before I cue it up, I'm going to cue it up for Ms. Burns, but in terms of the public comment that was made earlier about the comment about legislative visits, just as a recap, the Policy and Advocacy Committee met a couple of weeks ago, and that's myself, Dr. Erickson, and Dr. Kasuga, and we discussed the update on the legislative visits, and as you might remember, they happened the day of our last board meeting in the Capitol, and Dr. Phillips and Dr. Erickson were able to do some of those visits. So more about that will come up as we look at that strategy. I think this is our third or fourth year. Third, I think. So we've discussed that, and that'll be on our agenda as a committee the next time we meet, so there'll be more information. But during our committee meeting, we walked through much of what's presented on this agenda. So we'll walk through some of the recommendations from the committee to the full board for our consideration. So the first one is the sponsored legislation. As you might remember, AB 2968 is a bill that we sponsored and worked with the Office of the Assemblyman to get this on. So I know it just passed the Appropriations Committee 2 days ago. I think the email went out to the full board, but can you just give us an update, Ms. Burns, please?
Quick update, 2968 is sailing through the legislative process right now. We were on the consent calendar for appropriations because there's only minor and absorbable costs for the update of the brochure. So we are good to go, and we will go to the floor next and then on to the second house. So, no concerns yet.
So there's no action to be taken at this point. We've already supported, but is there any questions from board members about the bill, process, where we're at? Dr. Horn?
So, I had a couple of comments about the brochure itself. Do we get to make those things later, or what happens? This is just establishing that we can do it and we can make amendments to it,
Correct.
right?
This is just the legislation. This is
Okay.
not the actual discussion of how the brochure would be laid out. That's always been into two separate
Okay.
agenda items.
Okay.
This is just the legislation.
Great.
I'm going to make a suggestion that we put the brochure over to the next meeting because I know there
That's-
are substantive comments.
Yes.
I don't want to, I always feel like I'm leaving Ms. Jones in a position where she's putting a lot of time pressure on her, so I think that,
No worries.
Okay.
And at this point, where we are on the agenda, we're not discussing that part. So that'll be one of the ones, the discretion of our president to take that off of the agenda. But right now, the item we're discussing is just the legislation. Yeah. And it's passed the Appropriations Committee, so does it go to the other house now?
Goes to the floor first.
Go to the floor first. And I know Ms. Burns is not going to be able to probably do her presentation of the legislation. Or you did that last meeting, didn't you? The process, the pathway
Yeah.
of how a bill becomes.
It's all provided for your information,
Yes.
so yeah.
So in any case, just as a reminder, you can go back and look at the notes from last meeting if you want to see kind of the life of how a bill goes. But thank you.
I was gonna say, I believe it's it's in here, it's like 23 or something, so. you have any questions where we're at in the legislative calendar, it's in item, I think it's 23.
And I'll just go ahead, again, there's no action, but is there any public comment about this item, AB 2968? Okay, seeing none, we'll move to the next item, which is AB 282. Oh, goodness. Sorry, 1 second, please.
So she's 282?
Yeah.
Yes, and so this was discussed, AB 282, which is, it codifies the intent of the End-of-Life Option Act. We reviewed this at our Policy and Advocacy Committee, and the committee recommends the board take a support position. Ms. Burns, can you just give us an overview, please?
A quick overview, this provides that you would not be prosecuted under the Penal Code Section 401 for assisting in a suicide as long as you are doing the actions under the compliance of the provisions of the End-of-Life Option Act. So if you were a psychologist providing the mental health evaluation for someone that wanted to take advantage of the Dying with Dignity law, as long as you were in compliance with those legal provisions, you would not be prosecutable under the Penal Code. It's an old penal code section that penalized assisting suicide. This is just fixing the loophole that was left out there, so this is codifying that you're exempt from that.
And I do know that as a board, several years ago, we looked at this item and we were tracking it, correct? The other bill. Yeah. So basically, at this point, there is a recommended action from our committee. We recommend to the full board to consider a position of support for this AB 282.
Move to support the bill, AB 282.
Thank you. There's a motion, there's a second. Is there any board questions or comments about AB 282? Is there any public comment about the motion on the floor about the board taking the support position for AB 282? Seeing none, can we please call the roll for the vote, please?
Akwebadu? No. Bernal?
Aye.
Kasuga? Aye. Erickson?
Aye.
Fu?
Aye.
Horn?
Aye.
Jones?
Aye.
Phillips?
Aye.
Motion passes.
Thank you so very much. I'm trying to be so good paper light, and I was until right now. The next item on the agenda is AB 1779, and I believe that there is,
It's informational only.
there's some updates. So if you could give us that, because we did recommend a position in our committee meeting. However, there's been a change to the legislation.
Board staff contacted the author after the Policy and Advocacy Committee, and the author's no longer pursuing the bill. They will be supporting AB 2943, which makes it an outright ban under the Consumer Protection Act. So you wouldn't be able to provide conversion therapy services at all, instead of just protecting another subsection of a population. So they've decided to back away from this one at the time. I'm sure if 2943 didn't pass, they would go ahead and take another look.
So again, this is for informational purposes, no action, there's no bill at this point in time. Is there any board comment about this item or any public comment on this item? Hearing none, we'll move to the next item, which is AB 2044. And this is a bill related to child custody. And this is basically, can you just give us an overview of the bill, please, Ms.
Yeah,
Burns?
so the bill has 3 separate sections. One is on placing the safety of the child first in custody and visitation rights. The other part is a training component for that judicial council would have to add on domestic violence and the effects on children to their training for anyone that's involved in these court cases. And then the other part is the rebuttable presumption issues about if domestic violence has occurred in the last 5 years, extending that rebuttable presumption that custody would be detrimental to the child to domestic violence against anyone, not just that spouse or former spouse. So it extends some provisions that kind of outside of our personal purview. So we went ahead and made a phone call, and Ms. Jones can give you an update on that.
Yeah, let me just add to what Ms. Burns is saying, and as a committee, and committee members, if you have anything to add, please jump in. We discussed this issue, and we realized that not everything was in our jurisdiction, but we wanted to, given a lot of the conversation that we have had, mostly from public comment recently about this issue, wanted to make sure that we were putting forward information that the board is supportive of children, and we wanted to make sure folks were protected. So at the direction of the committee members, we said that one of us, and it ended up being me, met with staff, and we connected with the committee member, the committee staff member that's working on this with the Assemblyman's office to get more information about 2044. And if I'm not, I can't remember the dates, but I know that there's a little bit more work that's going to be done.
They have a stakeholder meeting on Monday.
Yes.
So a bunch of stakeholders will get together, and they'll be discussing the provisions on both sides of that issue.
So during the committee, we did not take any action, and given what we heard from the staff member who has been in contact with Ms. Burns prior to our conversation and is going to continue to be in touch after the stakeholder meeting, we hope to have more information that the committee will be able to review at our next meeting, and we will keep folks apprised of what's happening, but there is no action at this time because we are trying to determine if there is actually a role for us to have a position. Did I capture that correctly, committee members? Okay. Is there any questions or comments that you want us to think about as we prepare for our next meeting? Please feel free to share them. Is there any public comment also on this item? Seeing none and hearing none from board members, we'll move to the next item, AB 2138. And this relates to, well, we discussed this. This is a bill that would relate to boards denying applications as a result of criminal conviction. And the committee reviewed it and recommended that the board consider an opposition position for AB 2138. And as you see in the memo, primarily because of the consumer protections issues integrated into the licensing process. Since our committee meeting, there's been even more changes to the bill, which have caused staff to be a little even more concerned and wanting to bring to our attention.
Since that time, there's also been additional provisions about lowering probation to only 2 years, other provisions that are going to take away even more consumer protection ability for us. And then the biggest one would be the 90-day time frame for having all petitions for early termination of probation at 90 days, which essentially with our board and our petition hearing schedule would require an additional 3 board meetings a year just focused on discipline. So we've put our fiscal in. We've also been, there was a stakeholders meeting yesterday at the Capitol for all of the DCA boards with the Assembly Business and Professions. And there was quite a bit of discussion. It sounds like they will be first addressing amendments, hopefully they hope that will remove fiscal concerns for the bill to get it out of appropriations. Otherwise, it will stop at the suspense file due to the expensive costs for each and every board. It's going to add up quite high for all DCA entities, essentially. And then after that, they'd be addressing policy concerns in the Senate. So they're willing to work on some of these issues, it sounds like. And the gist of the meeting sounded like this is all the provisions we want, but we may amend down. But the primary concern for us is that all of these taken together, and even the opening foray about denial of applications, we already have due process in our application denial, and we have a pretty good system where very few are truly denied and not given a license. So we are looking for an outright oppose. There's just too many bad provisions in this one. We'll see where it goes, or if it even gets off suspense.
Yeah, I just want to add, I'm trying to find it in here, but in addition to the 90-day timeline to hear petitions for early termination probation, there was it was deemed granted if it was not heard within that time.
And during the Policy and Advocacy Committee, go ahead and answer your question. I'm sorry, Dr. Horn.
I was just asking, do you want us to?
Microphone?
I mean, you may be still explaining, I may be jumping the gun. Do you want us to vote on taking a position on this?
Yeah, so the committee had a recommendation for the board to oppose it, and I I just wanted to give more information since the memo and board packet were put together. The other item I just wanted to capture even a little bit more deeply that what Ms. Burns mentioned about our current processes. That was a question that was raised between committee members about, ensuring that we were not hindering someone's ability to pursue their livelihood. But we were told, Ms. Monterrubio was there, and we talked about the number of people that do submit and petition for reconsideration, and we have a process already in place. So just wanted to say that. But currently, the committee does have the recommendation to have the board oppose AB 2138. So is there a motion to do that action?
I so move.
Second.
So it's been moved and seconded. Is there any questions or comments or other thoughts for staff?
Quick question to Ms. Burns. Is the bill related to the Ban the Box movement that as a part of the
They talked about part of that as well.
And what was the author's response to our concerns that we articulated? I'm assuming informally, not in an opposed position, but about the process that we built in here at the board to address their issues.
They said they were receptive to the concerns and appreciated us coming, and it sounded like they were willing to negotiate with some sort of hierarchy of goals that they have, that I'm not clear on which ones are the top. So, but it sounds like they somewhat understand. There's also some other boards like Barber and Cosmo that have different issues that, interestingly enough, what they thought was helping people actually would hinder Barber and Cosmo's in-prison programs. So there's apparently some adverse random side effects from some of the other stuff that they thought they wanted for everyone, but that also would hinder certain programs like that. So it sounds like a very big discussion will be happening, first to get rid of fiscal concerns and then next to try to address policy. I think our biggest concern is the way they've gone about it is assume everything is wrong and ask for a wish list of things instead of asking our process to see, is there really a problem with the denial and if people don't get due process. And so it's kind of, let me throw the solution at you and then we'll figure out if that's the right problem.
Have we been contacted by the stakeholders in any way?
By the author's office or the
Not the author's office, well.
You mean like the sponsors? No.
For example, like I saw the Ella Baker Center as a co-sponsor of the bill, and I saw the ARC Anti-Recidivism Coalitions and other sponsors. So have they reached out to our office about the bill?
No. We've reached out to the author's office, and it sounds like they're going to go talk to their, not stakeholders, but sponsors, and see where they want to go. So.
And are there any other boards that have taken a formal position on the bill at this time? I didn't see that listed here.
Sorry, I missed that.
I'm so sorry. Are there other boards that have taken a position on this bill since the analysis was prepared by the BMP committee?
I didn't check on all the formal oppositions. I know most everyone has expressed their concerns, and then some like BBS are doing the same thing we are today and looking at legislation and within the last week or so. So having different meetings. I didn't look at med boards or osteos, so I didn't check if they've actually taken a position already.
And sorry, I apologize. I know we're
No,
running
you apologize. I was going to have a remark to what you said also. I think that it is important, as we talked about this, that staff has been having these conversations, doing in a formal position, and that accompanies a letter, which would then clearly articulate what those issues are. So just to answer that question in terms of being able to explain it, and I think also to give staff, not the power, but the ability to really be on the record from what the board is. That's also what's part of the discussion from the committee. But no need to apologize. Continue, I just wanted to add
One
that
last
answer.
question, and I promise that it's the one last question related to this item. So the oppose versus oppose unless amended, what was the general discussion amongst committee members and with staff about those two? I know you mentioned that it was a lot to negotiate down, and that's part of the reason why, but just given the intent of the bill and given obviously the negative impact on us and the built processes we already have here, what was the spirit of that discussion, I should say?
So staff didn't recommend an oppose unless amended. Usually, I think we've always operated under the assumption you oppose unless amended if you have clear and concise amendments that can make the bill better or workable for you. And I don't think the provisions, we were anywhere near ready to do that. So, and then there became more provisions we had problems with, at which point we didn't plan to rewrite the whole bill for them. It was just you've started off on the wrong track and you've taken a horrible left.
And quite honestly, I would answer it from the perspective of the fact is that this has been kind of our modus operandi when we, or like if we don't have a change, we were not saying that we are not supportive of the intent of all the work that folks are doing. It wasn't about that, it was about the consumer protections for the Board of Psychology. And so that's what we limited our focus on. And so given our process and talking to our enforcement folks, particularly Ms. Monterubio and staff about how it would work, we did not even entertain opposing unless amended, correct, committee members? It didn't seem appropriate.
Yeah, there were no concerns about the other side, about potentially supporting the bill, mostly because that it will really tie our hands as a consumer protection agency if this bill were to happen.
So are there any other questions? I know that we have the motion on the floor that was made. Any more board comments? Is there any public comment regarding the motion for the board to oppose 2138? Is that a comment? No. Seeing none, can we call the roll to vote on that motion, please?
Akwebudu?
Yes.
Bernal?
Aye.
Kasuga?
Aye.
Erickson?
Aye.
Fu?
No.
Horn?
Aye.
Jones?
Aye.
Phillips?
Aye.
Motion passes.
Thank you. Moving to the next item, AB 2943. Ms. Burns, can you give us an overview? I know you mentioned that this was kind of now connected, or AB 1779's efforts kind of ended and terminated with this bill. That's not the right exact language, I know, but I know that they're tied together and there's no pursual of that because of this bill.
So 2943 would make it an unlawful practice prohibited under the Consumer Legal Remedies Act, advertising, offering to engage in, or engaging in sexual orientation change efforts with an individual. It's also known as conversion therapy. Current law, it's only illegal for underage, so under 18. And the other bill would have talked about those under conservatorship or guardianship. This would just make it outright an illegal practice when you're paying for the service. So when it's a consumer service, it's not intended for if you went to your mic. Oh, sorry. The whole time, huh? So it's not meant for if you were to go talk to your pastor or priest or whatever. This is meant for when you are offering services for a fee, and then the advertising of those services for a fee as well. So this would ban that practice essentially for all, regardless of age.
Move to support AB 2943.
So there's a motion on the floor to accept the, well, not to accept it, but it's to approve. To adopt the position to support AB 2943. Are there any questions, comments about this policy action? Is there any public comment regarding the board, the motion for the board to support AB 2943? I'm hearing none. Can we call roll on this one item, please?
Akwebadu? Yes. Brunel? Aye. Kasuga? Aye. Erickson?
Aye.
Fu?
Aye.
Horn?
Aye.
Jones?
Aye.
Phillips?
Aye.
Motion passes.
Okay, and the last item, thank you very much, Ms. Chung. The last item that we are wanting the board, well, that the committee has requested a board position on is SB 1125, which deals with FQHCs, federally qualified health centers, and rural health clinic services that would eliminate or will allow a patient to see more than one provider in one day. And I know that we've discussed this notion about services in rural areas, and so the committee has recommended a support position for SB 1125, and I made it quick because I know that you have to leave.
No worries, super fast. It'll allow you to see your healthcare practitioner and then a mental health practitioner same day. No more barriers to access to care for people that already have a hard enough time to get into the clinic to be seen. So this essentially would make it just like if you needed to see the dentist as well. So.
This is specific to Medi-Cal though, too, right?
Yes, correct.
Do you, oh, I'm ready to move it into motion, sorry.
Go right ahead, Ms.
I would
Bernal.
like to.
You want to?
Second the motion.
So it's been moved and seconded for the board to support SB 1125. Is there any board questions or comments about that position? Is there any public comment about the motion for the board to support SB 1125? Seeing none and seeing some thumbs ups, we will go ahead and ask you to please call the roll call for this vote.
Akwebadu?
Yes.
Brunel?
Yes.
Kasuga? Aye. Erickson?
Aye.
Fu?
Aye.
Horn?
Aye.
Jones?
Aye.
Phillips?
Aye.
Motion passes.
Thank you very much. And board members, I would say in the interest of time, I will just say that the next sections are bills that we had just kept on the docket for us to watch. I don't know if anyone has any items they'd like to pull out to ask quick questions.
Staff would like to pull item J, AB 2143. There is a hand carry.
Ms. Burns, I know there was a concern about making appropriate arrangements. Can you stay for the purposes of this item, or would you need to leave?
I can stay really quick because I sent
Okay.
Sandra. Husband's locked out of the room with the baby.
Go ahead, Ms. Burns.
So, okay, really quickly. This bill right now, it was amended on May 7th, and it would expand the program to apply to persons that were mental health nurse practitioners and physician assistants. The biggest part of this is that in the legislation, it now would allow money for the mental health education program, so they would be able to get grant money if they are or were formerly a licensee and paid into the fund. So essentially, the way it is worded now, you could have paid into the mental health education fund and no longer be paying in and then get money, which is problematic for us. So you're allowing people that are not psychologists to use money paid in by psychologists. And then the other part would be, even if you are dual licensed as a psychologist and a mental health nurse practitioner for whatever reason you chose, if you're practicing as a nurse practitioner, you're not practicing as the psychologist, and so you're accessing funds that are meant for psychological services that are being provided as nurse practitioner services or physical medical health. So there's a problem with, normally the money is set aside, so MFT money goes to them, psychologist goes to psychologist. This would allow emptying of these funds from non-licensees, essentially. So staff saw these amendments on the 7th, which was Monday, and thought we better bring this up. This is a problem. We just got the fee raised to put more money into the fund, and we don't want the fund being drained out inadvertently. So we recommend and oppose as staff.
So again, given the timing of that, that's not been reviewed by the committee. So as a committee of the whole, staff is recommending that we take action to oppose AB 2143.
2143.
Oh, I can't believe my memory.
SB. It's
Got
SB,
that.
right?
AB.
Oh, AB.
AB 2143. So I saw some heads shaking as we were describing, because we remember this as part of Sunset Review about increasing fees. So is there a motion to have the board take this position of opposition?
So moved.
Second.
So it's been moved and seconded to oppose AB 2143. Is there any other board comment about this? And we'll get more information we'll keep track of this one as we will be opposing it. But this allows staff to write that letter and be very specific about what our issues would be. Is there any public comment about the board taking that position? Some more thumbs up. So there's no other comments. Can we have the roll call for the vote, please?
Akwebadu?
Yes.
Bernal? Aye. Kazuga? Aye. Erickson?
Yes.
Fu?
Aye.
Horn?
Aye.
Jones?
Aye.
Phillips?
Aye.
Motion passes.
So as I was saying, the next section 2 are the recommendations. We'll be looking more at this, more to come. I know that at this week's meeting of the Board of Behavioral Sciences, they were going to be looking at a position for that first one, so we will keep our eye on what's happening with all these other items, as well as the spot bills. And then the next section are the bills that are the 2-year bills that we're still going to continue to watch. I guess it's kind of a little bit of a misnomer. It wasn't approved by the board for watch status, it's just watch status. But we'll keep watching that as the committee. Moving down to the next section, I'm going to skip D for right now. Number 22 is legislative items for future meetings. How do you want me to do this, President?
You could open, I mean, you can just get there.
Are there any legislative items for future meetings? 1 second. I am skipping D for right now. I'm going to 22. Uh-huh.
So just want to make sure that CANRA comes back up wherever appropriate, so,
It's calendared to come up on future agendas.
okay. Thank you.
And in fact, we did look at the update at the Policy and Advocacy Committee meeting, and that did not come back over. There is nothing new to report, but we are definitely tracking it as a committee.
Legislative items for future.
Um,
I want us to ask.
So it has to be, so it'll be on the agenda item, but I just wanted to just give a report back of the committee meeting that we did discuss it, and that did not, that and legislative visits didn't get transferred over here, probably because we had such an impacted agenda, but we will make sure to include that from the committee for next time. Mr. Fu.
Just for 2138, I know the board's taking the opposed position, but I would like for us to have an update.
I'm sorry, 21, which one?
AB 2138, with the board, we just took a vote to oppose it, but I just would like for us at the next, in our August meeting, to revisit it and see where we are with the author's office and see if the policy committee feels like there's a desire to change that position, if the amendments that are made after the stakeholder meeting are more amenable to the board members.
Please know that for everything that we've taken positions on, we will do that.
Perfect.
And I think that just like we've come back and we've changed a position, we will definitely be keeping track of those. And those that we've taken a position on will be in a separate section and have a little bit more detailed information. Because we don't have the analysis and everything in that bill currently because it was at a watch status.
Right.
So there will be more to come on that. It happened on Monday. And when we...
Oh, sorry, this is the Chu and Low bill on the criminal convictions. But yes, I understand the point, which is we'll all revisit regardless of.
Absolutely.
So I appreciate that.
And actually, and the way we've decided to do this too is that for those watch bills, we don't go through them individually because it'll make the meeting super duper long. But each time we would like for people to look at them. Like last year, we had 2 that we kept pulling out. So and we didn't take a position, but we will track them. And if there's any of those bills that you want more information on, you can let staff know and we can get more on there.
Right, and that bill is not a watch bill, it's an opposed bill that we just voted on?
No, I understand what you're saying.
I
I understand what you're saying. I got what you're saying. I'm just explaining the process.
Understood, all right.
So for all the ones we take a position on, you'll get more detailed analysis and updates because I'm sure it'll take another step in the process. So we'll have more information on where it is in the process.
Right, and I would love to see if something worked out so that we could be supportive at some point, if it's possible, but just put that out there.
Fantastic. But we're moving to 22, so let's focus on any future items for legislative, because we did take care of that item, but we'll make sure we have more information on that one. Is there any other legislative items for future meetings that we would like to consider? Well, do you know that the committee will be meeting again in early July, and so we might bring more, and we'll be doing a review of everything that we took positions on today and the watch bill. And that is all for the, oh, and then 24.
No,
Okay.
let's skip that one.
I'm done. And number 23, we couldn't go into detail, but Ms. Burns had that legislative process. So that is the report from the Policy and Advocacy Committee.
Well done.
Wow.
Wow, okay, force of nature there. Thank you very much, Ms. Jones, I really appreciate it. We've got 4 agenda items left. We've got the EPP Task Force. This is the ones we're going to do, is number 25. We'll do number 28, which will be very, very brief. 29, we have the election, and then 30 is just the kind of cleanup at the end to see if there are any agenda items for the next meeting. So I'm going to suggest we take a 5-minute biology break, but 5 minutes only if at all possible. Yes. And then a very short closed session, additional session. Oh, yeah, excuse me. And there will be a very short closed session at the end of that because we have a very tiny bit of housekeeping to do relative to something we discussed previously in closed session. Okay. Thank you for that.
And
Yeah. 25, I want to recognize Dr. Horn for a brief announcement.
Thank you. I'm going to recuse myself for this agenda item. I work for ASPPB, and they are the creators of the EPPP, so I'm going to leave.
Thank you.
And we'll come and get you when it's over.
Don't go too far. Okay. So just want to give a quick update. The EPPP 2 task force, which me and Mr. Fu attended, and was held on April 5th, 2018. And basically during the meeting, at the end of the meeting, we decided to send a letter because there were some concerns that were raised. And the letter is attached on page 417. And we will be meeting again on June 29th. And by then, we're expecting ASPPB to respond to the letter that we sent. Any questions?
I just want to acknowledge Dr. Kusuga's expert navigation of having a large task force of, hello. Public comment's not yet time, but we welcome it, so we look forward to that. But just want to acknowledge Dr. Kusuga's expert leadership and navigation of the task force with so many different types of stakeholders and just being really inclusive of the different voices on the task force. So thank you for doing that, Dr. Kusuga.
Oh, thank you. And I just want to add to that the stakeholders, we really tried to reach out to a variety of stakeholders, which include professional psychology, associations, graduate school programs, students, prospective licensees, as well as doctorate internship programs. So we reach out to as many stakeholders. Any public comments about the EPPP? That's it.
Thank you very much, and thank you to our task force members for their hard work and to staff for pulling that all together. Okay, oh yeah, that's, let's get Dr. Horn. We're going to move on to agenda item number 28, which is my report. I don't even know what page it is, but we still have a vacancy here on the board, obviously, for a licensed board member. We are in contact with the governor's office to help in whatever way we can to get that additional appointment. And there have not been any change in the committees or the committee assignments. I think once we anticipate getting a new licensed member, maybe some people can lay a little bit of their burdens down. But for the time being, those remain the same. I think the meeting calendar is there. There are no material changes to the meeting calendar that I know of.
Policy and advocacy, do we have a date or no?
July 17th. I believe we're confirming. Oh, July 10th.
Sorry, yes, I believe we're confirming for July 10th.
Okay. And that concludes, I believe, the President's report. The next item on the agenda is the election of the Vice President. We have, in past elections, turned this over to Ms. Marks for purposes of running the election. We did have 2 prior nominees, as I recall.
I believe from the minutes, we had 2 nominees from the last meeting, and they were Ms. Bernal and Mr. Fu. There was a nomination for Dr. Kasuga, which she did not accept, and I believe it was also decided that we would wait. There was a discussion about whether or not it would be open for additional nominations at this meeting, or no?
You did say that we would have to reopen it and start over again.
Yeah.
Okay, so,
That's not in the minutes, actually. I'm thinking I didn't catch that, sorry.
is that everyone's recollection that we were going to not start with those nominations, that we were going to open it up for new nominations or just additional nominations?
What I remember is we're just gonna open it to a discussion if we're gonna keep the existing nominees, or if we want to decide to reopen the nominations. I think that's where we ended the last time.
I thought the process was, you said that because we were carrying it over, we would have to just start the process over again, is what I recall.
Doesn't it make sense to start?
I think my notes say we can vote to reopen the nominations at the next committee. So that would be the motion if somebody wanted to make it, which is to reopen the nominations. Does that make sense?
that we reopen the nomination for Vice President.
Second.
No, I just wanted to ask a quick question. Do I need to just reopen the nominations, period? Or do we just was the agreement just to reopen it for Vice President? I'm just asking.
Oh, I believe it was just for
Vice
the office of
President.
Vice
I just want to
President,
be
correct.
clear. Okay, I move that we reopen the nomination for Vice President.
Second.
So what does that mean, that new people need to be nominated, or same people need to be renominated, or anybody?
Whatever you guys choose.
It's like it hadn't been open and now we're opening it.
Did you, Ms. Gqueta-Badu, did you want to clarify your motion as to if reopen it for additional nominations or reopen it for new nominations?
Reopen it just reopen it, period, for new or additional or additional.
I think what I meant by additional, meaning that the nominations from last meeting are still on the table?
Yes.
Okay, so for additional nominations.
Additional nomination.
We have a motion on the floor, but yeah, I think that also, the other part of it is why we had, my recollection, we were starting over was because we also didn't get confirmation. One of the people that was nominated wasn't there, so I think we have to go through the whole process because we never confirmed with Ms. Bernal if she wanted to do it.
Correct, but because her nomination is still on the table, she would have the ability to indicate whether or not she wants to not
Got it.
accept that nomination.
No.
There's a motion on the floor.
No, I think we need to just vote on,
finish the
I think if
motion.
we vote on the motion
Yeah.
for reopening nominations for additional nominations for the office of vice president, you can then have the discussion
Yeah.
with whatever nominations are put on the table.
So don't we have to finish?
Correct. Right, that's what I said.
Oh, now
Yeah.
we're voting on the motion.
Correct. So then at that
Okay.
point, you would have the table open for. Yes, you do need to take public comment. I thought there was that asked? No. Oh, because
Yeah. It's true.
One part of the brain is over here. Are there any additional board?
Shay, you are so
Okay.
You're right.
Are there any additional board comments on the motion? Are there any public comments on the motion? Okay, can we take roll on the motion, please, to open the nominations for additional names for vice president?
Akwebadu,
Yes.
Bernal,
Aye.
Kasuga. Aye. Erickson,
Aye.
Fu,
Aye.
Horn,
Aye.
Jones,
Aye.
Phillips.
Aye.
Motion passes.
Okay, so my understanding from the last meeting, there was the nomination for Mr. Fu for the office of vice president, the nomination for Ms. Bernal, who was not present for the nomination. So, and there is now the motion that has passed to open up the floor for additional names to nominate for the office of vice president. Are there any additional names, any additional nominations? Okay. So no additional nominations. Okay, so then we have on the table the nomination of Ms. Bernal and the nomination of Mr. Fu. Okay, we can go by name, if that suits the board. Okay, the first one, I'll go in order. The first one we had was the nomination for Ms. Bernal for office of vice president.
Are we voting now?
We are now voting. So do you want to take roll on the nomination of Ms. Bernal for?
Akwebadu,
Yes.
Bernal,
Yes.
Kasuga,
Aye.
Erickson,
Aye.
Fu,
Aye.
Horn,
Aye.
Jones,
Aye.
Phillips.
Aye.
Motion passes.
Oh,
I think that probably then, is there any need then to put the nomination of Mr. Fu on the table?
You should.
What was the vote?
You know.
You're a parliamentarian by trade.
So why would we put Mr. Fu on the table? Okay. Okay, well, we have our officers, and I am sorry, I want to clarify that in the past, we have done the nominations for the calendar year. And unless there's a reason to change that, I would offer that the slate of officers is for the calendar year 2018. Correct? So we've got Dr. Phillips as president and Ms. Bernal as vice president for calendar year 2018. Is that right?
Please.
Before we get off of the item of elections, I just want to say, I do hope that we will take the advice, so the new leadership will look at that item 1 to be an executive committee, to do it in partnership, to look at everything together as we had in the past, and also that we consider doing a process where we are able to identify who is interested in being the officer, like Ms. Marks suggested in another board, that they do it like maybe a meeting before the vote voting election, just so that we kind of know who people are doing and that we are in no way violating the Open Meeting Act. And then thirdly, I would like just to say it's been a pleasure serving in this role as vice president for 3 years, and I do think that it is helpful to share the leadership, and so continue on. I'm here as a board member, not as an officer.
Thank you, Ms. Jones.
Thank you.
We really appreciate your service as vice president.
Thank you.
Yes, we do.
And the final item on our agenda then is moving on to number 30, is recommendations for agenda items for future board meetings.
Thank you.
Dr. Horn?
I have two things, and these are actually probably for, it would come up in the licensing committee. Yeah, I guess it would come up in licensing, but I'm not sure, so I know one would, but the other I'm not sure. So in the CE report, it seems to me like we have a high number of, I want to bring up that we take a look at if there is a trend, like let's look over the past few years at number of CE, percentage of people who have failed, licensees who have failed that CE requirement, and see if there's a trend. Are we getting higher? Are we staying about the same? What's happening there? Because right now we're close to 20% failure, right? 18%. Okay, so that's one item I'd like brought up in whatever appropriate committee before it comes to the board, or maybe just as part of the report. Yeah, let's just make it part of the report, yeah. And then the other thing is, this is just a question, when is CP, what's happening with continuing professional development? Where is this?
So I'm currently working on the eyesore, and we'll be sending that to legal probably next week.
On the what?
The initial statement of reasons
Okay.
for that.
It's called an eyesore?
Yeah. Sorry.
That's unfortunate.
So at the, I believe it was at the November meeting, the board approved the final language.
Yes.
And gave, and asked for rulemaking to be started. So what Ms. McCochran is working on right now are all the supporting documentations to start the initial rulemaking process. So that's where we are in the process.
So also an item for consideration would be the tolling, and specifically how we evaluate tolling as it relates to probation when the tolling is for either medical reasons or out-of-state reasons. And whether that's here as a full board or as a committee for the appropriate committee.
Do you think that should go to enforcement first, or?
I just want to get some clarification on that, because I believe the board approved the language for noticing. So is that something you'd want to discuss at hearing, or is that something that's like way in the future, or?
I defer to staff's calendaring of stuff coming up. So if it's,
Maybe it would be helpful just to understand, because we took a part of the tolling policy and considered it as part of the disciplinary guidelines. So if there's something in addition to that that you would like to address, like a statutory provision in regards to tolling, or a regulatory provision related to that, or what is in the disciplinary guidelines that you want to discuss?
I don't think it's necessarily the disciplinary guidelines. I think it's just more reflection on some of the cases we've seen, and over the last, at least during my time over the last year, where there was discussion at a higher level of where does the tolling fit in when someone is ill, or that which extends the probation period, or if they were out of state for various reasons, and how that extends the probation period, and sort of how, at what point, how do you get out of that catch-22, if you will. And so I'm not sure if that's a regulatory, statutory, or disciplinary guidelines. So I'd look to staff to help guide me on that.
We can include that in the enforcement report at the next meeting, an overview of tolling and how it works.
Well, I think it's more particular problems. There are situations in which people go out of state because that's where their career takes them, but they still have a license here that's under probation. It remains under probation indefinitely, even though they may be moving on with their career somewhere else. So I think it's a philosophical issue that perhaps we should first address in enforcement committee, then we can bring it back as part of the enforcement report. How does that, if the chairwoman is. I know you're, I know. I'm just trying to be respectful.
So you want information, that's what I'm hearing. No, we're fine.
I understand the issue, so I think I'll be able to articulate it at our enforcement committee meeting. Sure. So as long as it's on the agenda for enforcement, we'll remember to talk about it.
I have a follow-up question on something that we discussed previously in a board meeting with regards, I think it's more like an outreach question with regards having more students participate in board meetings. And I think one of the ideas that we put out last time was with regards highlighting some of the things that licensees, or like not licensees, but students, prospective licensees might be interested in, so we can get them to attend our board meetings. And given that the EBBB 2 will be probably discussed on our next board meeting, maybe like doing an outreach regarding that. Or just like, I just like wanted to follow up because it was previously discussed regarding getting more.
I think we did, right? We talked about reaching out, like, for LA, we could have reached out to the California School of Psychology and UCLA, and did we do that? I don't. Pepperdine, yeah.
Well, I'll follow up with staff, but it's my understanding that we always send out our agenda to our stakeholders list, and that's all the interested parties, including schools, early career psychologists, some of the consumer groups. So we have an identified list of stakeholders, and we always send an electronic agenda out. But there may be some targeted, we might get lost in the many emails and documents, so there might be a way to.
Maybe a little bit more of a personalized touch and calling a couple of the executive directors.
Or
important issues, like highlighting important issues. I think that's what we discussed earlier, that might kind of like attract more people. And given that it is possible that the EBBB 2 discussion will be on the next board meeting, that might be something that we can put on the outreach, just to promote possible people that are interested in attending our board meeting in the Bay Area the next time.
So this is just for agenda items that we're suggesting. We shouldn't have the substantive discussion now, so I think that gets it on the agenda.
Okay, thank you.
I just want to follow up on something that Ms. Jones suggested. I don't know if you want to put on the agenda the review of the board's administrative manual, because on page 13 it talks about the board's policy for election of officers. So perhaps you want to consider amending your administrative manual to include some kind of reference to nominating committee.
Thank you, Ms. Marks, I would like that.
Next board meeting's the one before the election, so I'll get the jury with something in the meantime. You know what I mean?
Yeah.
Anything else? Any items not on the agenda or that for future agendas from the public? We are going to go into closed session now, so don't go running off, board members. But members of the public, we thank you very much. We will be going back on the record at the end of the closed session, but it'll only be for the purposes of adjourning the meeting. Thank you very much for joining us.